Hey everyone. So I'm Zach Glazer. I'm an attorney out of Memphis, and I run a company called Tech for Lawyers, where we help attorneys and law-related businesses access and incorporate technology into their everyday practices. I also write articles and create CLEs on technology issues related to the practice of law. So today, I'd like to talk about the use of video conferencing in your practice. Now, this is obviously a big issue currently, and many of you are using these tools for the first time, or at least using them on a large scale for the first time. So we're going to go over how to vet one of these services, how to use these services, and then we'll look into examples of some of these platforms and some of the features that you'll likely want to look for. So briefly, for those of you who are uninitiated, video conferencing is a way to communicate with one or multiple people using your computer, tablet, or your phone. It connects audio with video when you're talking. FaceTime can easily be thought of as video conferencing. Zoom is one of the more popular video conferencing platforms right now. Um, Many times these applications will allow you to share documents, write notes to each other, and share each other's screens during the conference call. Now, there's a big push for attorneys to either expand their use of video conferencing or, as I said, simply start using it in the first place right now. And these tools can help supplement or replace a lot of actions that we take in our practices. One of the first things that I think of is obviously client meetings. You can, if you have a client that's even moderately tech savvy, you can easily have some of your client meetings via video conferencing software. But you need to do so, thoughtfully and with proper precautions. Another thing that people are replacing or supplementing is depositions. Depositions are very easy to take using video conferencing software. You don't even have to worry about using the video of the conference. You can easily bring a reporter or something like that into the video conference as well. So it's basically going to be just like if everybody was there, except that nobody has to travel, and you don't have to have the infrastructure. And this is one of the bigger things about the video conferencing, in my mind, is that you don't have to create this infrastructure of conference rooms and things like that. So a lot of the smaller practices out there will see that they want to use video conferencing because it gives them access to things that they didn't necessarily have access to before, like conference rooms. Online dispute resolution is something that a lot of people are doing via video conferencing, and this is a really nice one because people are able to set up multiple conference rooms and then bounce back and forth between them, as if you had a medium to large size facility in order to do that. But nobody has to travel, and the mediator can just bounce right back and forth between multiple conference rooms. Legal clinics are getting set up that are using video conferencing, and I think this is a great way to increase access to justice for people in some of the more rural areas in Tennessee. Obviously, we've got some very rural areas that are that maybe don't necessarily have issues with getting access to attorneys, but getting access to legal clinics are very difficult for some of these areas. And then the thing that I use video conferencing for the most is interoffice communications. Video conferencing can easily supplement some of the mechanisms that we're already using, like Slack or Microsoft Teams or Google Chat. Personally, I use Microsoft Teams in my practice, and it is very easy to be talking back and forth via text in a Teams chat. And then when we have to, easily pop into a video conference, and I can share my screen with people and show them things that we're talking about. And we can actually even keep recordings of those video conferences. That way, people can kind of go back to them and see what was going on. Now, I think these are all fantastic things that we do need to be incorporating into our practices here. But unfortunately, in our haste to get our client communications moving forward, many of us have neglected to look at the implications of incorporating video conferencing into our practices. So we're going to go over how to select a service, and we're going to go a little bit deeply into how to kind of nitpick some of these privacy policies that are out there and what you want to look for in the privacy policies. But But before we do that, we're going to get into the actual what we're trying to protect, our ethical obligations of these policies. So we're going to look at some of the things that you need to be aware of when selecting a proper video conferencing provider for our sensitive client communications. Now, if you're just talking to, your spouse, or talking to having a chat with somebody, or I think a lot of people are doing, virtual happy hours right now. These aren't that big of a concern. Like these aren't major fundamental privacy issues necessarily. I think Zoom may have some fundamental privacy issues, but they'll likely get that worked out at some point. But these are issues that we have because we're attorneys and because we're talking about our clients. So let's start by addressing some of the dangers of video conferencing, and what are the problems that we foresee, and what are the actions that we're trying to stop. And the first thing that we're trying to deal with is actually going to be the unauthorized access of a third party into our client information. Um, as with any online tool where we're interacting with our clients and sharing and storing information related to our clients, there's always a possibility that this information could be exposed to third parties, and that you could lose the information accidentally. But that's for later. We've all likely seen the news related to unauthorized trolls posting inappropriate pictures or videos in video conferencing rooms, or what's known now as Zoom bombing. And Zoom has actually responded with a lot of best practices, and hey, here's how you lock this up. But I don't know that these practices are good enough for law firms, for attorneys. Um, because for most, the issue here with Zoom bombing is one of seeing or hearing something that they didn't want to hear or see. However, for attorneys, the danger is actually kind of the opposite. Zoom bombing is, for us, the unauthorized access of a third party to communications with or about our clients. And this is very, very problematic for us. Um, so we've let an unauthorized party who's not related to this conversation into this conversation. And there are a lot of problems, including some attorney-client privilege issues, and obviously confidentiality issues. The second thing that we want to think about in protecting our clients and using video conferencing is going to be data mining. And this can be a subset of unauthorized access, but it can also be authorized access through your implicit agreements in the privacy policy, in the terms of service, or in the end user license agreement, the EULA. So data mining is a broad term that gets thrown around in a way that most of us really only have a vague understanding of what it is, and what it can be. At its core, though, it's really just taking a look at information that you have access to and drawing conclusions from your assessment. In our normal practices, it could be figuring out what source we get most of our clients from. Is it the internet, word of mouth, or an advertisement that we ran on Facebook? So the idea of data mining is not inherently problematic. The issue with data mining comes when we have to protect the identities and the information that we have about our clients. And we don't want to force our clients into a situation where they have to share this information with a third party in order to speak with us. In the real world, where everyone else lives, the sharing of this information is not really that problematic, as I said. It's more of a preference thing, or payment for a free service. The information is generally taken in the aggregate. There is not a lot of personally identifiable data being used. Um, Google and its advertisers, they don't really care that they're sending an ad to Zach Glazer specifically. They really don't care who I am. They just care that they're sending cat food advertisements to a guy that once visited the Hollywood Feed website. So they're not really that interested in connecting it specifically to me, but we really do get into some personally identifiable information because they're going to log my IP address, and then they're going to have a lot of information that's about me that may or may not have my actual name in there. And so this can be problematic for attorneys even at that level. And certainly any more information than that would be problematic because we owe some duties to our clients and we have some ethical obligations to their property. Um, Wielding your own data, um, saying, hey, I'd like to use Google's service and using your own information to pay for that is one thing, but using your client's information is a totally different animal there. And I think that we've got some ethical issues. And so we certainly have an ethical duty to protect this. And so what do we have to protect? And what do we need to watch out for when choosing one of these video conference providers? And the first thing that we want to look for, that we want to protect, is going to be client confidentiality. So we've pulled up Tennessee Rule of Professional Conduct 1.6, and it states in relevant part, and let me actually get the portion that is relevant to us here. It states in relevant part in Part D here that a lawyer shall make, reasonable efforts to prevent the inadvertent or unauthorized disclosure of or unauthorized access to information relating to the representation of a client. We all know this. We can't allow people to look at our client files. Essentially here, we have to keep unauthorized parties from getting to the information that we have or that we share about our clients. Now, this includes information about our clients themselves, like their name or their address, as well as information about the matter that we're handling for them. So this obviously isn't some draconian rule where we have to guarantee the safety of our client data absolutely. Except in the case of PHI, but this isn't a CLE on HIPAA compliance, so we're not really going to get too far into that. But those of you who have to deal with PHI, you know that you have to protect these things a little bit more than just reasonable efforts. But in reality, for most things, especially when we're just talking to our clients, we simply have to use reasonable efforts to protect this data. And in order to determine what reasonable efforts are, in Tennessee at least, we look to comment 18 here. And specifically in comment 18, this area right here, the commission has given us some factors to be considered in determining the reasonableness of a lawyer's effort. And these include, but are not limited to, the sensitivity of the information, the likelihood of disclosure if additional safeguards are not employed, the cost of employing additional safeguards, the difficulty of implementing these safeguards, and the extent to which the safeguards adversely affect the lawyer's ability to represent clients, ergo by making a device or important piece of software excessively difficult to use. So we're looking at kind of a balance here of how difficult is it to use, and then what is the benefit that we're getting out of using this. So as a side note, I doubt in this situation, a lot of times with video conferencing, I doubt paying a monthly fee to a provider is going to be considered an unreasonable cost to safeguard your client information. So if it simply takes paying for the service to protect your client information, then that's likely what you need to do. Unfortunately, this isn't always the case. Many times I tell people basically to buy their way out of these privacy issues. When you pay for a service, with Microsoft or with Google, a lot of times if you jump into that pro plan or into the paid plan, then their privacy policies actually are very different than what they are in the free plans. So you can see that we need to balance the fact that the video conferencing is making our relationship with our client cheaper and more convenient, with the dangers of the confidentiality of their information that these applications pose. So the next danger that we want to think about is the privacy of our client information in and of itself. So, and not just the confidentiality, but the privacy of this information, the fact that someone may be looking in, or third parties might be able to even hear our conversation. And this comes in two flavors. First is going to be attorney-client privilege, and then just simply protecting the personal information of our clients as well. So, for Tennessee attorneys, excuse me, I've had this up for a little while. For Tennessee attorneys, the attorney-client privilege actually comes from TCA 233105. And if we can't get this up, that's going to be okay because I've got it memorized or written down here. It says, no attorney, solicitor, or counselor shall be permitted in giving testimony against a client or person who consulted the attorney, solicitor, or counselor professionally to disclose any communication made to the attorney. This is the important part for us right now, is that we're not permitted to disclose any communication that our clients have made to us. We all know that if we had a client meeting in an open or public place like Starbucks, then it's likely that the meeting would not be covered by attorney-client privilege. The client, doesn't really have a reasonable expectation that the communication was private in that scenario. And the same goes for if we allowed a third party to listen into our phone calls with the client. If the client knew about it or had a reason to think that that was the case, then they wouldn't really have any good reason to think that the call was private. So to that end, if we give access to a third party to the content of the discussions that we have with our clients via video conferencing, it's likely that those communications could lose their privilege as well. Now, I'm not saying that it definitely is going to lose the privilege, but I doubt that any of you want to defend that motion in a hearing. If you're standing there in front of a judge saying, "Judge, my client still had an expectation that these were private," you're in a bad spot. And this is not only time consuming for you, but it is, you're going to be charging your client for this or not charging your client. And that's even worse. So the other side of our privacy discussion is going to be, keeping personal information confidential or private. And there are kind of two flavors of this. And one is personally identifiable information. And this goes to the client confidentiality that we talked about above. Any personally identifiable information about your client, you're going to have to keep confidential. And then, personal health information, PHI, which will be covered by HIPAA or the HITECH Act. And you obviously have a duty to protect these with either reasonable efforts or completely and without question in the case of PHI. So having a third party have access to this, whether it's authorized or not, if it's not authorized by our client, is problematic for us. So now, the third issue that we want to be aware of when selecting a video conferencing provider is our duty to maintain and protect our client files in general. So the safekeeping of property and funds is a big issue here. So 1.15b in relevant part states, other properties shall be identified as such and appropriately safeguarded. Complete records of such funds and other property shall be kept by the lawyer and shall be preserved for a period of 5 years after termination of representation. So we have an obligation to preserve our client files for at least 5 years. And this may include, video depositions, documents given to us by our clients, information shared with us by our clients. And as you can see, a lot of this information, this type of information, may be stored in one of these video conferencing platforms. And we have a duty to make sure that these files are not only protected from third parties, but also protected from accidental loss or corruption. And the Tennessee Board of Professional Responsibility has actually put out multiple formal ethics opinions on the 5-year line for protecting our client information. And we can see that 5 years is actually a minimum. It is kind of a bottom line. So you may also have a duty to protect these for more than 5 years, certainly for at least as long as the statute of limitations is run on it or is running on it. So in order to assess these dangers in a provider, we generally look to the privacy policy of the company. We want to see what they say they're going to do with this information. Now, keep in mind, though, these policies generally have they generally have something in there that says that they can change them at any time. and sometimes even without notice to you. So how do we look at a privacy policy? And actually, I've got Zoom's old privacy policy up right now. And we're going to take a thorough look at this because this is an example of one that should raise some red flags. But let's get an idea here of how to look at a typical video conferencing privacy policy. And our main concern is the data that they collect and store related to us and related to our clients. And this data, it's all information that's related to us and related to our clients, but a lot of times they call it different things. And one of the first things that they're going to call it is going to be personal data. So every one of these platforms is going to collect personal data on you and the client and any other user there is. Some of this information collection is normal and necessary in order to allow you to actually use the system. Knowing what operating system you have, which browser you're using, or remembering your IP address for a certain amount of time. That'd be good examples of this. So many times websites display differently based on which browser you're using, so you can see things better. And you would never get information back from the system if it didn't remember your IP address for a certain amount of time. So these aren't inherently bad. And if they're used in the aggregate, you're likely okay with just this information. Again, we're walking a balance of reasonableness here. Additionally, if you're using a video conferencing solution like Zoom or Microsoft Teams or WebEx or something like that, it may be necessary to keep track of the name that the user gives as their name in the chat, or to store other information that you want to keep track of. You know, if you're exchanging files, then it may need to store that file at least temporarily, or if you ask it to for a limited amount of time. But what is typically not necessary for the system to actually function is for the program to give another party access to this information. It's not inherently nefarious. It just may be something that attorneys can't allow to happen. If you share the identity of the participants with a third party, as we said, you may be in breach of your obligation to keep your client's information confidential. And if, let's say, Google has access to the contents of your communications, you may also lose your privilege. Now, just as a side note, this is an issue with email as well. If you were using a free email provider, if you have Joe Attorney or Jane Attorney at gmail.com, this is probably a problem that you have with attorney-client communications, with attorney-client privilege. So you want to think about this there as well, but certainly it's an issue with video conferencing. The next type of data that a lot of these privacy policies are going to talk about and a lot of these companies are going to collect is going to be user-created content. And again, collecting this content is not necessarily nefarious. We're talking about the contents of your chats or your whiteboards that you share in the system, things that you create as you go. And again, in order for this information to even be there, some of it likely needs to be collected and stored by the provider. And with a proper business associate agreement, it likely won't be a problem for the provider to simply collect and store this data, even if it is PHI. Now, another aspect is going to be data that you exchange back and forth with your client. How do these providers protect that data, and how do these providers treat that data and store it? A platform may collect and store files and data that you and your client exchange over the connection. This could be photos of driver's licenses. Automatically, you see how that could be problematic if a third party got access to it. Contracts that have been breached, or images of text messages exchanged with the opposing party. So sometimes if the system allows it, you, the user, will actively save this information with the provider. So again, this is not inherently nefarious or even problematic. We just have to make sure that they're dealing with this information appropriately. So the first thing we want to do when looking at privacy policy is determine what information broadly they're actually even going to collect, or they're gonna have on you and your client. And one of the bigger things with reading these policies as an attorney is that you need to read these with the thought that, okay, this information is going to be collected on me, and this information is going to be collected on my client, whether they want to or not, frankly, if you're asking them to use this. So it's kind of the difference in reading this privacy policy as a regular user and then as a attorney. So our first problem comes with a question of protecting this data from unauthorized outsiders. Um, so we want to look at what sort of security does your provider use, and is this security enough for our purposes? Obviously, we're going to want to keep, some hacker in China or California or wherever they are out of this information. And the initial thing you're going to want to look for in one of these privacy policies is going to be end-to-end encryption. And end-to-end encryption means that while the data of your conversation is traveling from one party to the other, like the video feed, it's encrypted. So it's basically encased in a tunnel of encryption. You can't read it while it's there. Essentially, a party who intercepted this information would not be able to decipher it, and for all intents and purposes, wouldn't be able to access this information while it's moving. So we call it in transit. So while it's in transit, if a service does not have this, do not use them. I don't generally have a lot of specific you can or can't to do this, because again, these are this is what is reasonable under the circumstances. But if they don't have end-to-end encryption, I will go out on a limb and say that that is not reasonable under any circumstances, unless you really just don't care if your information is private at all. So if you have any thought of having private information, then you have to have end-to-end encryption. So, excuse me, this end-to-end encryption doesn't protect your information when it's sitting in the data server somewhere waiting to be accessed. So as this information is going back and forth between you and your client, some of this information is being stored in a alternative place to for you to be able to access later. So if you take a picture of the driver's license, or frankly, if you take a picture of your bar card or something and you transfer it, this is going to be stored in a data server somewhere. And so you want to make sure that the provider is doing something good to protect this data. So this is a little bit more difficult of a question because it's how safe is safe enough. Obviously, we can make this data so inaccessible that even you can't access it, and so we can lock it down so much that it doesn't provide us a benefit at all. And this is what we're talking about in comment 18, where we want to make sure that we're still able to use these things. So a complete discussion of data security is a discussion for another time. Generally, however, you want to make sure that the provider is using tools that are generally accepted in the industry, or using a provider themselves who is a trusted entity when it comes to data security. So for example, using Amazon as a data service provider is likely a good idea. Amazon stakes its reputation on being a data service provider, on having their information secure from third-party access. So now those two are just a discussion of what the provider is doing to keep unauthorized parties from accessing the data they collect on you. In addition, we also need to look at who it is they're authorizing to have access to your data and what data they're sharing with them. This is where a lot of these companies get into some problems when they're not specifically created for attorneys. Again, sharing this information with a third party is not necessarily nefarious. A lot of times it's just kind of the cost of using the service for free. But with attorneys, with our attorney-client relationship, we can't have a third party, authorized or unauthorized, a lot of times access this information. So now a lot of these questions and concerns, a lot of how these companies do this, can be gleaned from a thorough reading of the privacy policy. Now, this tells us how the providers expect to deal with your information at the present time. Again, these policies are mutable and therefore not extremely binding. So we want to look at what the policy looks like right now. But then we also want to try to get a feel for what form it may take in the future, because again, it can change. And we don't have a crystal ball. But as attorneys, we are generally used to trying to look at what we think is going to happen, and assess risk. So we want to do that here. And remember, we're talking about reasonable efforts to protect our client information. So we want to look at things like how recently was the policy changed? How big of a change was it when they changed the policy? What did it say previously? How often do they change the privacy policy? And if they change it, this is one of the bigger ones. If they change it, will you know, or will you be given an opportunity to leave the service? And if you were given the opportunity to leave the service, will you be given the opportunity to take your data with you? And then the least scientific is, what's the tone of the privacy policy? This is my favorite one, because it's really just kind of like, what feel do I get from the writers of this privacy policy? Um, and that's not going to make a privacy policy just tank for me, but it's going to kind of add to the balancing factors here. And again, these are all balancing factors. There's not going to be any privacy policy that just kills it on all of these. So just very quickly, like I said, we're going to take a look at a few privacy policies and point out some of the language that we want to look at. And so we're going to be looking at both of Zoom's privacy policies to show you why we may want to look a little deeper into just the current policy, to make a determination about the safety of our client data and their confidentiality. So what may make us want to look a little bit deeper, and what we may find. So Zoom specifically has had some issues lately with their privacy. And when I started this video, I thought, I don't want to beat up too much on Zoom, because Zoom is really out there in the spotlight right now. And companies are going to have issues. They're going to have some privacy issues. We're going to have some bugs in the software. This is why these companies have bug bounties. And I started off this thinking I don't want to, really go too far into bashing Zoom or anything like that. And I don't want people to think that it's that. But as I continued to go with this video, more and more information kept coming out about Zoom's privacy. And I have to say that I would just suggest that if you're talking about attorney-client communication, just first off, it is at this time likely not a good idea to use Zoom. Their privacy is just not up to spec. And so we're actually going to use Zoom's privacy policy as an example of red flags. And they've actually been called a basket full of red flags by some writers, actually this one specifically. Sorry, a bucket of red flags. Zoom is a bucket of red flags, and we're going to go through their privacy policy, their old one and their new one, in order to kind of look at what some of those red flags are. And unfortunately, I am going to beat up on Zoom a little bit, but it's because of what's going on with their privacy policies, frankly. So, a lot of the problems that Zoom has had have actually not necessarily been related to their privacy policies. It's been related to their infrastructure and the real versus perceived privacy of the conference rooms. So, in response to some of the issues that they had, Zoom actually changed their policy on March 28th of this year. And they changed it significantly. However, the snark that was in the original policy is still in the new policy. And I don't know how original this policy was, because this is the old policy. And it was actually created or changed on February 23rd, 2020. I didn't really look into how much of a change this was, because really the change from the February 23rd to the March 28th policies were so significant that it raised red flags to me anyway. So the first thing we're going to look at, we're going to dive into the privacy policy of Zoom, but the first thing that we're going to look at is really going to be this, the collection of your personal data. And we want to figure out what it is they're saying that your personal data is. And with Zoom, you can see your personal data is going to be some things that identify you, such as your name, your username, your physical address, your email address, phone numbers, other similar identifiers. And again, when we look at this, we don't want to think your name. We want to think client's name. So they're going to be collecting our client name, our client's username, possibly our client's physical address, their email address, phone numbers, and other things that identify them. So that's just giving us an idea of what kind of stuff that they're going to be collecting. And this is in the personal data category. They're also going to collect information about the device network, internet connections, such as IP addresses, MAC addresses. And this is the stuff I was talking about that is not really problematic. This is very normal stuff to collect in order to make the system run. And this isn't, abnormal. It's just something that we want to be on the lookout for as attorneys, because it's client information. So we go a little bit further. In Zoom's privacy policy, we actually find that they also collect something called customer content. And this is cloud recordings, instant messages, files, and whiteboards that are shared while using the service. So this is things that the customer created content. This is stuff that we make in there. And they say that they are collecting that information. And again, I would expect them to collect that information in some sort of way, to at least store it in some way. So this is not problematic. The question is, what sort of access do they allow intentionally or unintentionally to this information? And so the first thing that we're going to look at is, how do they use or disclose the personal data? And through here, basically, you get a sense of they're using and disclosing it for the purpose of running, personalizing, improving, operating, maintaining their product. Very normal sort of thing, and to be expected. And then down here you can see facilitating your use of the product features. That's also a very normal thing, following the instructions of our users, and keeping you up to date on the latest products, announcements, software updates, software upgrades, et cetera, et cetera. So again, this isn't majorly problematic here. And obviously everybody's going to have to use it to comply with their legal obligations. Where we get into a problem with Zoom, and this is the specific area that you're going to want to look at in privacy policies, is what do they do with your information as it relates to Google Analytics, Facebook Analytics, and other third parties that want access to your information. This is the entities that are authorized by them, implicitly authorized by you, but these are third parties, and they're going to use this information for their own purposes. So Zoom starts off with, do they sell this information? And frankly, I don't, for our purposes, I don't really care if they sell this information or not. I'm not worried about what their definition of sell is. I'm worried about whether or not they exchange this information with somebody. And so this is not really that important of a paragraph to me, other than the fact that if you read it completely, it starts to make you feel like Zoom is splitting hairs in their privacy policy. And I don't like to have that in privacy policies. I don't like to feel that way. And again, that's not going to, doom a privacy policy in and of itself. But when coupled with some problems in the policy, then it's going to make me feel, worse and worse about it, and start to move me away from using it, especially if there are other options out there. The issue here, though, is that Zoom says that they share personal data, that definition that we have above, with a third-party provider. And they're going to share these with Google Ads, Google Analytics, and they're going to share it with Facebook. So right here, we have a problem. Excuse me. And this is what I'm looking for. What are they doing? They're taking what could be personally identifiable information and they're giving it to a third party. And so to me, unless there is a compelling reason to use this specific service, like there's no other service out there or something like that, then we don't need to be using this. And if there is a compelling reason to use this service, we need to make sure that our clients know that this information is being shared. Now, you can protect yourself from this somewhat in some ways by turning off cookies in your browser or by using a safe browser that automatically turns off cookies and turns off tracking and things like that. But your client isn't necessarily going to know to do that. You're just bringing your client into these things. So if we can avoid it, if there's another service that does this better, then I'm going to use that. And again, that doesn't necessarily kill everything, but we want to be aware of that. So next, we want to look at, so again, this is, do they exchange for payment? And they say that you can opt out of this sort of quote unquote sale. So you can get your way out of this. A lot of places kind of let you buy your way out of this, but you can kind of secure your way out of this. But what we want to look at now is data retention. What do they do with our information when they store it? And what I'm looking for here, again, like we said, is something that says end-to-end encryption, or a lot of times it will be denoted as E2E encryption, big E, the number 2, big E. And like I said, if they don't have end-to-end encryption, then you really don't want to use one of these services. And it states here that they use the TLS encryption technology for the transfer of credit cards, and that is very standard. If they don't use the TLS, that'd be problematic. But other than that, they really just state that they utilize a combination of industry standard security technologies, procedures, and organizational measures to help protect your personal data from unauthorized access, use, or disclosure. In my first reading of this, if there weren't any other problems in this, or if personal data wasn't such a broad thing, I may not have major problems with this, but this would certainly raise a red flag, and so I'd start to look into whether or not Zoom does have end-to-end encryption, because they don't come out and say it. And we'll see here in a second that they also don't come out and say it in the new privacy policy. So as I was doing this video, we actually found out, or some articles have been written, that Zoom meetings are not end-to-end encrypted. And to take this for what you will, I haven't completely vetted everything, but again, this raises a lot of questions about whether or not Zoom's privacy policies are appropriate, or even the protection of our data is appropriate. So I'm going to have to go ahead and assume they don't have end-to-end encryption here, and that's going to that's going to kill any possibility of using this product that I would have. And so hopefully, they would put that end-to-end encryption in the next privacy policy. Hopefully Zoom will start to use end-to-end encryption and start to hone in on what they want their privacy policies to be. Until then, I don't think attorneys can really use Zoom. But you be the judge. I'm not here to tell anybody exactly what to do. But I really would suggest that you look into this a little bit further. But let's look into Zoom's current privacy policy. And this isn't so much to just beat up on Zoom, as much as it is to kind of show some of these red flags that we have. And right off, as we scroll through this, you see that this has fundamentally changed, at least in its wording. Now, this was created on March 29th. So March 28th is the last use of this old policy. And first off, we start, this was in a response to some major privacy issues that they have. And so first off, we start with a letter or message from the chief legal officer saying they value your privacy and everything like that. And so I appreciate that. And I think that's kind of the idea that we want to get into. But they're kind of behind the 8 ball here. They're starting from a little bit behind. Now, this is all very different from the previous one, but let's look into it from itself. So if I saw a major change in the privacy policy, or more importantly, if I saw a very recent date for a privacy policy, that's going to make me look at what it said the other day. This is why we look at the Zoom privacy policy previously. Actually, one of the main reasons that I had this was because they actually changed their privacy policy in the middle of me doing this video. So that was interesting. So they start off with they don't sell your personal data. Whether you're a business, school, or individual user, they don't sell your data. I'm not concerned with selling the data. I'm concerned with transferring the data to a third party. So again, let's go down. Let's look at what they say the data is, collection and use of data, and we're going to really buzz through this one because we need to do some other things. Type of data they collect, information that identifies you. This is what I'm concerned with here. And they say they use it to create customer account, provide Zoom services, communicate with the customer, respond to requests for support. All generally pretty good. So that's making me feel a lot better about this privacy policy. But let's keep going because they actually have 3 areas that they talk about information that they have. So this is data that we give them. And here is data that the system collects on us. This is the technical stuff that I would expect. All this stuff is pretty necessary in order to run the system. And then recordings here, they've kind of gone into the we actually don't let others access your recordings. So that's good. I'm glad they clarified that. And then here's data you can choose to give us. And so it's information that identifies you, your name, username, physical address, email. And this is where it's problematic, is that this is personal data that is going to be sent to a third party. And it says they'll use it to send you marketing communications unless you tell us not to. Or if you say it's okay, i.e. opt-in. That's problematic to me as an attorney because my client may not know not to do it. I may have to tell them to do that. So, and then at the same time, this is kind of saying it both ways, unless you tell us not to, or unless you tell us to. So I really don't get a great feeling with Zoom looking through this privacy policy, but let's keep going. Again, we can kind of like protect ourselves out of here. We can train our clients to protect themselves out of this. So it's not a complete killer, but what is going to be what they do with our data, data retention. And again, we don't have anything here that says that they use end-to-end encryption. And so that's the biggest killer for me, is the lack of end-to-end encryption from Zoom, coupled with the fact that they collect so much data and then give third parties access to that data. There's no reason that they have to give third parties access to our names, our client names, our client email addresses, our client addresses, things like that. It's not absolutely necessary. And it's an extra hoop that I would have to jump through in order to prep my client for meeting with me via Zoom. So if you are using Zoom, don't, because of the end-to-end encryption, but if they get the end-to-end encryption sorted out, then you're going to need to make sure that your clients know how to turn their cookies off or how to use a browser that goes ahead and does that inherently in order to protect themselves, or at least they know that this information is going to be shared. They may be okay with it, but you are going to have to give them the choice. So we got about 10 minutes left here, and so we're going to very quickly go through a product that is kind of on the other end of the spectrum here, because it's built specifically for attorneys, and this is called Legaler. And Legaler is a platform that is a video conferencing platform built specifically for attorneys to exchange information with their clients. It dovetails into a platform called Clio that I think some of you are familiar with. I hope that they'll actually get it connected to some of the other cloud-based content management systems out there. But keep in mind, Legaler is not the only system out there. There is Mega Meeting. There are many, many other systems out there. So, and they're likely, I haven't really gone through everybody's privacy policy, but they're likely going to have a privacy policy that's a lot more like this Legaler privacy policy. Excuse me. Now, the first thing we notice in going through this one is last updated over 4 years ago. And so this is, to me, at the time, a stable privacy policy. And it hasn't raised red flags yet. So I don't feel the need to go look to see what the privacy policy was on February 14th of 2016, because this has been pretty good so far. It's been stable for 4 years. I I don't think that it's necessarily going to change anytime soon, unless they roll out some new services or some new products, and that would be an understandable change to the privacy policy because they would have to tell you what they're doing, what some of their new things are doing, and all that. Um, the first thing I noticed actually in reading this policy is that the tone is a little bit different. It's a little bit more helpful, and you would expect that because they're talking to attorneys here. They're trying to say, hey, this is a safe thing to use. But let's let's go through and see what types of data they collect on us. And they say that personal information is data that allows someone to identify or contact you, including, for example, your name, address, telephone number, email address, as well as any other non-public information about you that's associated with this. So they do collect, kind of a broad idea of what personal data is. And again, much like with Zoom, that's to be expected because we're kind of giving this information to them. A lot of times you want to know the names of the people that you're connecting with. And so this is to be expected. We're they're going to have this in here. And again, the question is what sort of access do they give to this? This is information, and this actually is what makes me very happy about Legaler's privacy policy is that they tell you, they break down what the personal information is for the clients and what the personal information is for the lawyers. When your client is reading this, this is very simple for them to understand. They can see what sort of information is actually being used to identify them, and they can make an informed choice without me having to go in there and help them make this informed choice, frankly. And then for our purposes, this is the information that they're going to keep on us. I'm not as concerned about this because I understand that they're going to do this. I'm going to give them most of this information, professional memberships, qualifications, areas of practice, photographs. I'm going to give them most of this information. But what we want to know is how they use this personal information. And so obviously they say they use it to administer it. They're going to use it to show everybody. And this is something that you can read very easily. Your client can read very easily. Now, they do collect cookies, and they do actually share this information with third parties. But so similar, we may share sensitive data so long as it's not aggregated with personal data and therefore cannot be connected to any person. This is not super problematic to me because again we can kind of help ourselves out of this. The thing that is great about Legaler, and I imagine some of these others, is right here. Legaler goes into a lot of detail about how to opt out of this. Again, they say they're going to use Google Analytics with some of this information, but they tell you specifically to install Google Analytics opt-out browser, and they tell you exactly where it is. So now when I'm connecting with my clients, I can say, if you don't want them to collect information on you, please use this this add-on in your Google Chrome browser, or use Brave as your browser. And actually, I've been testing out Legaler, and the Brave browser, which is a very secure browser, works very well with Legaler, and you don't have to give them, you don't have to open up cookies or anything like that. So it does function without having to use the cookies. And the difference here, because they do collect the same basic data that Zoom does, and they do connect this data with third parties, but they give you a they give my client a much better understanding of how to keep from doing that. If my client doesn't want that information to be sent, then they can easily go in here and protect themselves. And I can, instead of having to explain this to my client, I can say, hey, listen, go look at the privacy policy in this specific area, and it's going to tell you how to opt out of getting this data sent to Google Analytics. So it's not so much that they can't send this information; it's that they're trying to help you not send it there. Obviously, Google wants this information, and a lot of times this is being used to help you with a service. So, but this red flag kind of raised and then brought down a little bit because they do such a great job of helping you understand, helping your client understand how to keep this from happening, as opposed to, Zoom's privacy policy that seems to be, kind of speaking out of both sides of its mouth and not really talking about how they keep the content. So preservation of the content, they are going to keep this content preserved for a particular amount of time as long as they consider necessary. And then they go into the security of this. They use physical electronic procedural safeguards and use reasonable efforts to protect your personal information that they collect and maintain from misuse, interference, loss from unauthorized access, modifications, or disclosures while it's in their possession. They provide client-side and server-side encryption, resulting in end-to-end encryption and zero-knowledge password authentication. That's what I'm looking for. That's the thing that sets them apart from Zoom right now, other than the fact that the tone of this privacy policy is much more helpful to me as an attorney. And keep in mind, I get to choose what platforms that I use. But this is, they at least claim that it's end-to-end encrypted, and that is going to be huge. They also go on to say, we can't say that this is 100% secure, like we know, and they say you need to protect yourself as well. But they go into it's a different tone here in trying to help us protect this. And they get into how they use Google Analytics specifically, and we've already said how to get out of it. But they also have an easy way to kind of opt out. You can send them an email, much like you can do with Zoom's privacy policy, but they tell you exactly how to opt out of these things. So that's legaler. And now we've got about 4 minutes to talk about some of the platforms and services that you want to use. So just very quickly, one of the things I look for in these platforms is going to be manageability. How difficult is it for my client to use this platform? One of the things that Zoom really has going for it is that people find it very easy to use the platform. So it is a very manageable thing to do, pieces of software to install. I have found a lot of times that Microsoft Teams is difficult for people. And although you get a lot of benefit out of it, I think it's the one that I use, but it is not easy sometimes for my clients to set up. So the user experience isn't necessarily the best thing. So when you're looking at these platforms, you want to think about how your client is going to experience this and how difficult it is going to be for them to set up. Is it something they can do on their phone? Is it something they can use their iPad with, or if they have an Android tablet, or are they going to have to use their laptop? Then I like to find something that has concurrent rooms. Zoom has concurrent rooms. Legaler has concurrent rooms. I can set up concurrent rooms with Microsoft Teams, but you want to make sure that this is something that you can kind of bounce back and forth between two rooms as needed, especially if you're going to use this as a mediator or with online dispute resolution. But I think it's good for attorneys just in. Then we want to make sure that we've got some form of chat among the channel. And this kind of exists with most of these. But the thing that I like to look for is, do you have a secure chat that you can do with one specific person? Can I talk with my assistant or my team member while I'm in a conference call with a lot of people? Then we want to make sure that we've got file share in these in the platform. Can you exchange the files over the platform that we have to the meeting? Excuse me. Can I choose which users have access to these files specifically? Can I limit the access of other people? So we want to look at, we've just gone through an hour of privacy from third parties, but also kind of privacy from the other people that are using this. And one of the most important things for me is the ability to screen share. And most of the ones that you're going to look at, Zoom, Microsoft Teams, Legaler, WebEx, all of these are going to have the ability to share screens at the same time. So you can help your team members do things or, debug things. Then we want to look at conference room security. Is there password protection for the conference room? Does somebody have to have a password to get in? Can somebody just jump in if they know where it is? Do we have waiting rooms for people that we can kind of keep them outside of the conference room prior to bringing them in? And then can I limit the invite to just people that I invited, to just specific users, to where they're the only ones that can get connected with it? So those are some of the things you want to look at. And a lot of these platforms have all of these, but these are going to be things that you're going to want to think about as you're getting a little bit further away from some of the mainstream. And then lastly, integration with other platforms that I already use, because again, just because I use Microsoft Teams doesn't necessarily mean that you want to use it. Or just because I use Legaler wouldn't necessarily mean that you would want to use it. Legaler integrates with Clio wonderfully, but Microsoft Teams, although it doesn't integrate with Clio, integrates with Office 365 software very well. And then there are many, many other integrations that it uses. Zoom integrates with Slack. So if they can get their end-to-end encryption game going and kind of make me feel a little better about some of the privacy, then it's a great tool to use inside of Slack. And then all the others generally integrate with something out there. And so you want to see what are the other pieces of software that you're using that you can bring this video conferencing software into. I find it very, very helpful to be able to conference call out of something that I'm already using. And so some of the services that we have, there's Microsoft Teams, and this is obviously the platform that I use the most, mainly because it integrates with Office 365 products. But I found that it's one that's kind of difficult for people to use. Google Hangouts is another one that's out there. I haven't vetted this one completely for security, but I have looked into Google's security policies as it relates to their G Suite mail. If you're going to use Google Hangouts, I would suggest that you at least get up to that G Suite level, use get a business account, and then read what the privacy policy says in this business account, kind of how we went through it. One of the good things about Google Hangouts, and frankly about Microsoft Teams, is that you can have a VoIP. You can have your phones go through this conference calling system. So you can actually have conference calls as well as video conference calls a lot of times. So that's very helpful. Now Zoom, again, is kind of a basket full of red flags when it comes to security, but they've got some wonderful features that are useful when talking to your clients and keeping track of your conversations. So if they'll get their privacy game back on, then I would be a lot more comfortable with Zoom, because they are a very good product, kind of fundamentally for people just talking. They're just not necessarily a great product right now for attorneys. And then, as we said, Legaler is a product that will integrate into Clio. You can have, it's extremely, extremely easy to get your client into a conversation on Legaler. Their user experience is one of the best that I've seen right now in talking about connecting with your client initially. It really is a stark contrast to Microsoft Teams, and I really use Microsoft Teams all the time. And for those of you, I'm sorry, I probably should have said this much, much earlier. Microsoft Teams is Skype. So Skype for Business has now become Microsoft Teams, and so they're essentially the same service. So when you're saying, "Oh, what about using Skype? What about using Skype?" That's Microsoft Teams. And I know a lot of people have trouble with Skype for Business or Microsoft Teams and getting people connected. And then I know a lot of people, would have some trouble with WebEx. And there are a lot of platforms out there that you have to make sure that people have the right settings with. I just read a LinkedIn post on some of this Zoom privacy issues, and somebody said, "Well, what do you expect me to use?" Microsoft Teams doesn't work for everybody. I have to disable some of the security protocol on my Mac in order to use Microsoft Teams. I have to get certain things set up in order to use Google Hangouts or some of these safer things. You're just going to have to fight through those things, because Zoom is not the one to use right now. But I would suggest to just sit down and kind of work through your workflows. Now that we're using these video conferencing platforms more, it would be good to go through some of the videos on how to use these, how to set them up, how to get your clients set up. You're going to want to go through Make sure you vet the privacy policy for these guys. That's the first thing you're going to do. And then let's look into some of the features. Make sure it's got all the features that you want, or that you could want. And then determine whether or not it's got proper integrations for you. And once you make the decision, once you choose which sort of video conferencing software you want to use, then go and educate yourself on this software. Go watch the videos on how to use it, because the excuse of I can't set it up is not good enough for attorneys. Get somebody that can set it up, or go figure out how to set it up appropriately on your Mac or your PC or your iPhone or your Android phone or your tablet or whatever it is that you're using. These larger companies, certainly, like Microsoft and Google, are going to have instructional videos out there to show you how to use it. But I would say even the medium to small companies are going to have instructional videos on how to use these things and how to set them up. You're not the only person that has the issue of setting this stuff up. So if anybody has any questions, I know this was a lot of very, very dense information, a lot of going through some specific privacy policies. But if anybody has any issues or any questions that they like to ask, because this is not an actual video conference and you're not getting to do it in real time, you're always welcome to send email to me at support@techforlawyers.com, and that is TECH, the number 4, the word lawyers, and .com, and it's right there if you want to see it. So or you can go onto the website and you can click this nice little support button, and it'll let you contact us. And you can ask us any questions you want, and we'll do our best to get back to you. Good luck finding a video conferencing service. I hope this has been helpful, and thank you very much for listening for this long.